Hello, everyone. Welcome to another episode of Know Your Law with dotlegal. My name is Hassan Aziz, and I am the principal solicitor of dotlegal. We have with us today Mahmood Mando. Mahmood is a barrister at Edmund Barton Chambers. Mahmood joined the bar in 2013 and practices in criminal law. Thank you so much for joining us, mate.
Yeah, thanks for having me, Hassan.
You're welcome. Our topic today is criminal trials and everything around it. So let's get into it and let's ask Mahmood. Mahmood, first question: what are the pre-trial procedures and what can one expect?
Okay, well, a criminal trial is usually a proceeding which relates to more serious criminal offences. So what happens is the matter initially commences in the local court in what's called the committal proceedings. And then what happens is once the matter, the accused is committed for trial, the matter it goes to the district court or the Supreme Court, depending on what the offence is. The more serious offences would go to the Supreme Court, such as murder and manslaughter and things like that. But most criminal trials go to the district court, and that happens after a case conference certificate is filed in the local court, or if a case conference is not required to be held because, for example, the accused is unrepresented or a question of fitness to be tried has been raised. And then the accused is committed after a charge certificate is filed. And so what happens then, once the accused is committed for trial, the matter goes to, in most cases, the district court. And in the district court, what's called an indictment is presented. Okay, and that indictment basically refers to all the charges, and it can involve more than one accused, but there has to be only one operative indictment before the court. And so even though it can include a number of charges and a number of accused, there has to be one current indictment. What happens in the district court is that the accused is arraigned, and what arraignment is, it's basically when the charge or the charges in the indictment are read out to the accused, who is asked to plead to the charge or charges, guilty or not guilty.
Right.
And that's it. Yes.
Right.
Yeah.
So you talked about arraignment. The next question then is, obviously in district court, a jury would be selected or impaneled. How is the jury selected or impaneled?
Okay. Before we get to the impanelment of the jury, there's because important steps take place before the impanelment and after the arraignment. After the arraignment, what takes place is like a pre-trial rulings. So where the accused has been arraigned, the trial court may make orders for the conduct of the trial in relation to, for example, evidentiary matters or procedural matters affecting the trial, and also, for example, including in reference to disclosures that are required by the parties and notice requirements and things like that. So, for example, the accused is required to put on a notice of alibi evidence or notice of substantial mental impairment if that's relied upon, and there's other things like it'll be clarified, by the judge asking counsel whether there are any challenges to the prosecution evidence by the defence, and what that means is any challenges to the admissibility of prosecution evidence, and then that will involve rulings. So if there's an argument or a contest about whether certain evidence is admissible or not, there will be a hearing in relation to that matter, and there'll be a ruling in relation to that. And obviously there's other procedural matters that can be the subject of pre-trial rulings, such as like having an application for a separate trial in relation to offences, like separate trials in relation to different offences, or separate trials in relation to different offenders, because sometimes the proceedings are commenced against a number of co-accused. And one co-accused may have the view that it may be prejudicial for him to be in the same trial as another co-accused, for example. So there may be application to the appeal court, the Court of Criminal Appeal.
Right.
And so that brings us out to the empanelment stage.
Yep.
So once all that's done, once all these pre-trial rulings are dealt with, it brings us to the empanelment stage. Empanelment of the jury is basically where candidates are selected from the community, from a bigger pool of community members. So these are candidates for the jury, okay? And there's a large panel of these candidates selected from the sort of the community. They're brought to court on the day of the trial. And from this panel, in turn, are selected the actual jurors who are going to sit in on the trial. Okay, so the panel is one thing, the jury panel is one thing, and the jury is another thing. So the jury is taken out of the, or taken from the jury panel.
Right.
And so after empanelment, although it may not be strictly necessary for the accused to be rearraigned before the jury panel, it's a good idea. It's a good practice for after you have a panel of jurors, potential jurors. The accused is then basically arraigned in front of these jurors, so they know who this accused is and what his position is, that he pleads not guilty.
Okay.
In relation to the offences.
Okay.
Yeah.
So then we come to the next question, which is, what is the structure of the trial?
Okay. So when it comes to the trial, it starts off with essentially once the jurors are selected, there's this process of, I'm sure you've heard, challenge. So what happens is, both while the jurors are being selected, they're selected by ballot. So they're each given a number while they're sitting in the jury panel. And then all these numbers are placed in the ballot box, and their numbers are selected out of this ballot box. Whichever juror's number is selected has to get up and has to basically appear before all the parties in the court. And both the Crown and the defence have a right to challenge without cause. They have a number of challenges without cause that can be made without cause. Usually it's about 4, basically given or placed to the charge of the jury. So this is in effect indicating to the jury that it's now this person is now going to be judged by this jury, basically.
Yep.
So then, in terms of the process after this, there's the judge's opening. So the trial process commences once the jury is selected. The judge opens. The judge makes a number of important opening remarks. In particular, he talks about the trial process generally. He describes the roles of the different parties, the roles of the jurors themselves, the role of counsel, the onus and standard of proof, the imperative of not discussing the trial with any person outside the jury room, the prohibition against making inquiries outside the courtroom, including using the internet, for example, or visiting the scene of the crime. And the judge has to indicate that is a criminal offence if the jurors do that. So if a juror goes and does his own investigations, that's a very serious matter. And other things, the judge would also tell them that this is a matter that should only be discussed, or directions to the jurors are usually placed on a piece of paper and that's given to the jurors at the start of the trial. So they're reminded of what they need to do and not do. Are you there?
Yes. Yes, go ahead.
Okay, so it will call, as well as a brief summary of what evidence it is anticipated each witness will give. And then also the defense will also give its opening if defense counsel chooses to. The defense opening, one has to be very careful with it, because defense counsel should not embark on an impassioned plea based on factual assertions that have not yet been established by the evidence. So the defense counsel would normally basically set out what the issues are in the matter, and if there's anything agreed with the Crown, a factual matter that's agreed with the Crown, that's fine. The defence can refer to that. That's not an issue. The defence, nor the Crown for that matter, should talk about what the law is into too much detail, because that's the job of the judge, really, to talk about what the law is to the jury. So any factual assertions that are referred to in opening should not be an issue, essentially, unless it is clearly indicated that these are an issue, and it can be indicated where agreed that certain factual propositions are not in issue, but that has to be agreed, of course.
Okay. So obviously you've discussed that in detail, and the other question that people would want to know is, and they hear about it often, which is a judge alone trial, and how is a judge alone trial different to a jury trial?
Okay, with a judge alone trial, that is an application that can be made. It has to be made at least 28 days before the commencement of the trial in either the district court or the Supreme Court. It can be made, and the order will be made if both the defence and the prosecution agree on it, of course. Now, if the prosecutor doesn't agree on it, then what has to be established by the defence is that the order would be in the interest of justice, and the court, the matters that the court will consider in deciding whether to make an order for a judge alone trial are things such as whether it considers that the trial will involve a factual issue that requires the application of objective community standards, including but not limited to an issue of reasonableness, negligence, indecency, obscenity, or dangerousness. So if the court considers that these are very live issues in a particular case that need, I guess, the community objective standards of a jury, then the court may disagree, may say, no, this should not be a judge alone trial. It needs these community, the community's understanding of what these are, like what is reasonable, or what is negligent, or what is dangerous. The court may refuse that application if it considers that those matters are very significant in the case. But if the court is convinced that they're not, then yes, the court may make that order for a judge alone trial. In relation to matters which involve more than one co-accused, all the co-accused, all the defendants must agree to that application. If the trial involves more than one accused, for it to be a judge alone, all the co-accused must agree to that.
Right. Okay. Well, thank you very much for the detailed information on a trial. We appreciate it. Thank you
You're
so
very
much for joining us today, Mahmoud. Thank you.
welcome. Thank you for having me. Thank you.
Thanks.